So this is the second video for topic 5, and we're going to explore what it means here for the terms to be complete. There are, as I mentioned earlier, 3 aspects to contractual certainty. Agreements need to be complete. That means there needs to be agreement reached on all the essential terms. The agreement needs to be certain, so the terms themselves must be certain and clear in meaning. And the terms must not be illusory, so the promises need to give rise to actual, not illusory, obligations. So basically what I want to cover in this video is that idea of completeness. Before I do, I want to raise this question. Is completeness really a formation element at all? Oh no, I hear you say, Kath, we've been talking about formation elements all this time. Agreement, which is made up of offer and acceptance, consideration, intention, and certainty. Surely certainty is a formation element. Whether or not it is really requires you to apply a little bit of legal logic. In uncertain and incomplete agreements will not be enforced because the courts can't be sure what was agreed. Completeness means only that the parties have to have set out all the essential elements of their agreement, or that they've specified an agreed means of ascertaining what they are. So a contract will be enforced if the parties' intentions are clear, or if those intentions can be ascertained with reasonable certainty. Essentially, formation is in a way part of the idea of offer or agreement. In order to have agreement, we need to have certainty. So we could in fact bundle these things in together, and you'll notice that in some texts and even in some of the materials that I've provided to you, for example, the Andrew Valakunas video that is available for you on the discussion board, which talks about the ways to use Iraq, he talks about the Trinity, formation Trinity, which is agreement, because the idea of completeness or certainty is wrapped up in that, consideration and intention. Now, when you think about it, given that we can provide or eliminate the need for consideration by using a deed, perhaps offer an acceptance or agreement and intention are really the only true formation elements. Sorry, playing with your mind a little bit there, hey? So going back to our overview model, you might remember, I just want to pick out this part of it. This is what we're going to talk about today. Is the purported contract uncertain and incomplete? In order to answer that, we need to question, what does incomplete mean? The key authority here is the case of Hall and Bust, which looks at the extent to which it omits an essential term that cannot be filled by a court. The Latin term is ut res majus valeat quam pereat. In other words, it is better for a thing to have effect than to be found void. So let me be effective rather than being found void, and explain that a little bit more clearly. Take a look at Whitlock and Brew in your casebook. Whilst it can be a little bit tricky to work through that judgment because there are 3 different judgments to think through, Kitto, Taylor, Menzies and Owen all come to the same conclusion, but the basis of Kitto's reasoning, which is really informative about this issue, is slightly different from the decision of Justices Taylor, Menzies and Owen. And then ultimately too, we have a decision from Justice McTiernan, which is a dissenting view. He ultimately found the opposite of the other judges. In that case, as you'll remember, the question was whether a clause in a sale and purchase agreement for property rendered the whole of the contract void. Because if the contract was void, then no contract, and the defendant would be entitled to get the plaintiff would be entitled to get their deposit back. But if there was a contract and it was enforceable, we have a different result. So in that arrangement, there was a sale of land on the basis that the land would then be leased back. And the parties had not yet reached consensus on what the terms of the lease would be in any detail. The clause said that the property would be sold on the condition that the purchaser would grant a lease of the land on such reasonable terms as are commonly govern such lease. Now, it's actually quite a precise type of transaction, and Justice Kitto points out that if there were leases of this kind in common use, then it would probably be quite easy to determine what that was, and there would have been certainty. But objectively, looking at all of the facts of the case, there wasn't sufficient certainty in this case, that we didn't know what those terms would be. The judgments of Taylor, Menzies, and Owen, Justices Taylor, Menzies, and Owen, is also helpful because they point out the issues with the arbitration clause, which I haven't mentioned on the slide here. They say that even though there is this opportunity to go for arbitration, the role of an arbitrator, similarly the role of the courts, is not to provide the terms. It is merely to assist the parties to interpret the terms. So in that case, it was held that the expression upon such terms as commonly govern such a lease could not be, in the context in which it appeared, apt to refer either to the period of the lease or the rent payable. So the reference to reasonable terms would have been sufficiently certain had there been such a set of terms in common use, but the evidence didn't establish the existence of that term. So that brings us back to our overview diagram and reminds us of Hall and Bust, which actually I didn't mention in any particular detail. You'll find Hall and Bust in your casebook at 6.65. And that's the case about Badara Island and the sale contract for the land, which was to incorporate some fixtures and fittings. But basically the language was not sufficiently clear for it to be certain as to what was intended by that wording. So I like Chief Justice Dixon's words here. The value of all additions and improvements is not, in my opinion, sufficiently certain to give rise to an enforceable contract. He goes on to say, can it be supposed that men contract to pay a price if and when fixed by a jury in a lawsuit? What does that remind you of? Reminds me of Justice Kirby in the Woolworths decision, and reminds us that it's not the job of the courts to fill in the gaps to make the contract for the parties. What the role of the courts is to do is to interpret what the contract gleaned from the written documents or the behaviour of the parties means. So essentially what it asks us to do in order to determine whether there is a complete contract is to consider the question of whether all the essential terms are clearly addressed. And in doing so, we need to work out what an essential term is. So whether a particular missing term is essential will depend on the nature of the contract and the circumstances of the case. You'll find more explanation of this in the Tramways and Luna Park case. In relation to what's an essential term, well, I'm going to move on to that in a moment, but we can, with almost some real certainty, agree that the identity of the parties, the subject matter of the contract, and the price are almost always going to be essential terms. The last thing that I want to remind you of is that an agreement to agree in the future is not generally an enforceable term. It can but a term that leaves something to be fixed by a third party may well be. So let's go through this and make sure that we understand. So what is an essential term? An essential term is a term or a promise that is of such importance to the promisee that they wouldn't have entered into the contract unless they had been assured of strict or substantial performance of that promise. And this ought to have been apparent to the promisor. Those words are taken almost word for word from Tramways and Luna Park. What actually matters here is whether the court can enforce the contract in the absence of a missing term. What terms do we need to believe to be essential? Again, depends on the context of the contract, but parties, subject matter, and price will almost always be there. In relation to a contract dealing with land, stipulating the identity of the land or the subject matter is absolutely crucial. Where if we are talking about a contract, say, for the sale and purchase of iron ore, the quality might be relevant, but the single individual grains of iron ore will not be. So again, you see the context is what is important in this circumstance. Time periods too are often really crucial. Something needs to be done by a certain time. Something that you will see from time to time in contracts is this idea that time is of the essence. Reflecting on that word essential here, an essential term, if you see time is of the essence in a contract, that means that timeline requirements, so times for giving notice, times for delivery, must be adhered to very strictly, or it will give rise to a right to terminate the contract. And we'll talk about the reasons for that when we start to talk about conditions later on. So what are some examples of essential terms? In a lease agreement, for example, the commencement date and the rent to be paid would almost always be essential terms. Sale of land agreement, the identification of parties, the land itself, the price, but not necessarily the settlement date or the dates for performance of a range of other things inside the contract. Sale of goods, what the goods are, not necessarily the price though, because in this case legislation, the Goods Act 1958 of Victoria, can imply a reasonable price in certain circumstances. What's the point here? The point is what is essential will very much depend on what the contract is about. A good illustration of this comes from the case of Milne and the Attorney General of Tasmania, a 1956 High Court decision. So in that case, the High Court, through Chief Justice Dixon and Justices McTiernan, Williams, Fulliger and Taylor, after referring to certain documents which the plaintiff alleged contained the terms of the contract, said, and I quote, "Furthermore, apart from the fact that the general purport of the communications in questions evidences anything but an intention to affect legal relations, those documents deal with only some of the terms which must of necessity be settled before a binding contract can exist. This is not really a case at all where the parties are negotiating with a view to contract, but even if it be treated as such a case, no contract is concluded until the parties negotiating are all agreed on all the terms of their bargain, unless indeed the terms left outstanding are such as the law will supply." And we'll talk about those later. Here, the transaction ultimately contemplated was a very complex character, and it is clear that the law cannot supply its terms. So when is a contract incomplete? Essentially, these are the kind of questions that you can ask yourself in order to work through a kind of checklist if you want. So first start with how important or essential is the missing term? That question comes from ANZ Banking Group and Frost Holdings, 1989 Victorian case. In that case, Frost submitted a proposal to the ANZ Bank which was accepted in principle but subject to some changes. ANZ subsequently advised Frost that it didn't want to go ahead, and Frost claimed a breach of contract. In that case, it was held that there wasn't any agreement on the essential terms. Where a relevant or a critical term requires a future agreement, it isn't enforceable. It's okay to agree that part of the contract will be settled by a third party or by a third party arbitrator if the parties cannot agree, because all the matters between the parties have been settled. Here there was an absence of the agreement concerning the style, size, quality and price of the proposed calendar. The next question to ask yourself is, why was a term left out? Did the parties fail to reach agreement? Did they defer agreement on the matter? Or did they just not turn their minds to it? Each of those questions or each of those assumptions leads to a slightly different conclusion. If they failed to reach agreement on the matter, that suggests that a no agreement was in fact reached. If they put off reaching an agreement until they got more information, that suggests something different. And it might be that there is some sort of third party calculation or some ability to imply a reasonable price or a reasonable term. If they fail to turn their minds to the question, that suggests that maybe the term is not essential, if it's not something that they needed to look at. May and Butcher and the King is a case which concerned whether or not in the sale of land a good contract could be found where identifying the price or determining the price was to be done by the purchaser. And it was ultimately found that was too vague, that the price was an essential term, and that setting the price by the buyer couldn't be a binding obligation. It couldn't fall within the principle that where the words by themselves could constitute a promise that showed that the promisor is to have a discretion or an option, that if that was so broad as to essentially make the promise illusory. So that it was incomplete for the lack of that term. The next question that we ask ourselves is whether the agreement has been wholly or partly performed by one side. Now, this is here where we trip close to this idea of past performance, and we remember that past consideration is not good consideration. In the case of Foley and Classic Coaches, the plaintiff had sold some land to some defendants on which they were to carry on a motor coach business, and the plaintiff retained a petrol station on some land that adjoined. They reached a kind of supplemental agreement where the plaintiff would, during his lifetime, at a price to be agreed, continue to buy petrol from the petrol station next door. After 3 or so years, they decided to move on and not purchase that petrol anymore. And ultimately, the Court of Appeal found that they were prepared to imply the essential term, to imply a reasonable price. Now, in that case, it was relevant that they had continued on the basis of the agreement for a 3-year period. It's a difficult case to reconcile with May and Butcher and the King, but it does demonstrate that the land had actually, because the land had been transferred and the parties had acted on the agreement, that the courts will step in to imply a reasonable term. The last question goes back to the case I was just mentioning previously, Milne and the Attorney General of Tasmania. We need to ask ourselves how equipped the court is to fill the gap. So in Milne and the Attorney General of Tasmania, they found that they were not so well equipped. Similarly in Hall and Bust and in Whitlock and Brew. In those cases, the judges said, we cannot find a reasonable basis on which to fill the gap here. The parties didn't turn their mind to it, or if they did turn their mind to it, they didn't reach agreement, and it's not the role of the courts to write the agreement for them. So what happens when you have an agreement that includes a formula for setting the term? You will see this quite regularly in lease agreements where there will be a regular period for rent review and the lease will go up by reference to a formula, maybe 2% or the consumer price index for all goods in Melbourne, whichever is the higher, something like that. Question always arises whether this is an agreement to agree at a later time. In fact, it is possible to create a formula for reaching agreement, and the rent increase by CPI that I've given you is a very common example. The validity of the formula will, or the contract itself, will depend on whether the court finds that the formula or the standard that's been adopted sufficiently certain. Is it objective? Is it capable of being applied in a systematic way? If the mechanism or the machinery fails to supply the essential term, then ultimately the contract will fail and be void for uncertainty. I mentioned a little bit earlier in relation to sale of goods that the Goods Act and its sister acts across each of the Australian jurisdictions will imply a reasonable price in relation to the sale of goods. Relevant section is on the screen, section 14, and it provides that where there's an agreement to sell goods on the terms that the price is to be fixed by the valuation of a third party, and the third party doesn't make the valuation, then the agreement can be avoided, provided if the goods or any part of them have been delivered or appropriated or used by the buyer, then the buyer needs to pay a reasonable price. Where a third party is prevented from making the valuation because the seller has defaulted in some way or the buyer has defaulted in some way, then the party who isn't at fault can maintain an action for damages against the party in fault, notwithstanding the fact that the essential term, price, isn't in the document. So what about an agreement to negotiate? Isn't that the same as an agreement to agree? Frustratingly, it depends. Once again, we need to objectively look at the circumstances and determine what the situation is. So think about the following promises. The parties agree to negotiate in good faith the precise terms of a more comprehensive joint venture agreement, or the parties are to mediate in the event of a dispute arising out of this agreement. Are these sufficiently certain? Um, is a concept like negotiation or negotiating in good faith or mediating a negotiation enforceable? What exactly are the parties required to do in terms of negotiating a more comprehensive contract or mediating a dispute? Um, Justice Kirby in Ayton, Australia Proprietary Limited and Transfield said that a promise to negotiate in good faith will be enforceable depending on its precise terms, so long as the promise is clear and part of an undoubted agreement between the parties. So a promise to sit down and negotiate is enforceable, but we know that an agreement to agree later is not. So take a look on this point, particularly at United Group Rail Services and Rail Corporation. It's at your casebook at 680. It's a good example case here because it goes through the legislative history and it looks particularly at the key case of Coldcliff Collieries and Sajima and Ayton, Australia, the case that I just quoted Kirby from. So, and you'll see that the agreements to negotiate in good faith can be enforceable provided that the promise is sufficiently clear. And the promise needs to be a promise to negotiate. It's not a promise to reach agreement as such. So in the next next little video, I'm going to start talking about what it means for the terms to be certain and clear in their meaning, which we've started to touch on already, I know. So take a moment beforehand to just make some notes and make sure that you're comfortable with this idea of the completeness and completeness requiring all essential terms, and essential terms need to be clear and certain as well. It's overlapping, I know.